Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And we are back with this motion in limine from the Northern District of Illinois. And so I posted the first video for you guys, and I was getting ready to post the second video when I read through the comments. And those of you who responded to my little survey about whether you would like the longer version of the video or for me to break this up in shorter videos. And for those who have responded, it seems that you prefer the longer video. But on top of that, someone, a fellow YouTuber, actually messaged me and stated that if YouTube is flagging my videos, I shouldn't break these videos up because that's going to accumulate a lot of flags, and I don't want that. So to just do the longer video, then it'll just be one flag or two flags in this instance, because, you know, whatever they're flagging it for. So anyway, I'm going to go ahead and just do the long version, save myself some trouble and some time, and hopefully move past whatever it is that YouTube has going on that they don't like my videos. But anyway, here we go. So I'm going to start from the beginning for those who haven't watched the first video, and we'll just do the one long video, and I'll do a premiere and then go back and break the sections up in the description, and that way people can just go to whatever point of the video that they want to go to. So it says government's consolidated motions in limine. The United States of America, through its attorney, John R. Lausch, Jr., United States Attorney for the Northern District of Illinois, respectfully moves the court in limine for entry of orders admitting or excluding certain evidence and argument at trial in this case as set forth below. And then, as I pointed out in that first video, basically what they are going to do in this document is set the stage for blocking every angle or defense that Jennifer Bonjean can imagine having to defend this case, okay? And so they're going to be trying to block identification of witnesses. They're going to try and block the consent laws. They're going to, you know, like the people couldn't have consented. Just whatever they can throw at the wall. Like they have looked at this, reviewed it, and said, oh, they might try that. So let's go find case law that prohibits them from doing that, that supports them not being able to have that defense. Oh, we're not going to let them talk about the parents. Oh, we're not going to let them talk about this, that. And so that's what you're going to see as we go through this document. And so for those of you who are wondering, what in the world am I talking about? This is the case against Robert Sylvester Kelly in the Northern District of Illinois. Okay, and so those who've been following this, they get it. And those who are new, you're going to have to pick up on it, okay? So it starts out with the first motion is motion to protect the identities of certain individuals. And so we saw this in the Eastern District of New York case where people want to go by pseudonyms and either their first name. And so here they're saying that they basically want them to be able to use only their first name and to prohibit anybody else from using their last name or anything like that. So it says that the government moves to protect the identities of the individuals named in the superseding indictment, who are currently going by numbers, who are expected to provide and or will be the subject of sensitive and personal testimony concerning abuse and production and receipt of videos by the defendant. Specifically, the government moves the court to 1, permit the individuals to testify using their first names only; 2, limit references to each of the individuals in open court by their first names only; and 3, prevent public disclosure via cross-examination or otherwise of individuals' respective addresses, full names of family members, or exact placement of employment, if any. So it's, I guess some of them don't have jobs. Okay, so I'm going to go back up, and there's a note. And so the note says, for purposes of efficiency and ease of reference, the government has filed in motions in limine in a single document. No single motion herein exceeds the 15-page limit as imposed by the local rules. And then 2, the government also intends to raise at the pretrial conference additional courtroom procedures and logistics to accommodate the individuals, such as the use of separate entrances. Okay, so then it goes on to say the superseding indictment charges defendant Kelly with multiple counts of enticement and exploitation of the individuals. The individuals are expected to testify in explicit detail and or be the subject of highly sensitive and personal testimony concerning Kelly's conduct with them that occurred many years ago. Due to the sensitive nature of the testimony and evidence relevant to the crimes charged, the government seeks entry of a proposed protective order limiting the disclosure of the individuals' last names and other identifying information in court. The limited protections requested by the government are necessary and appropriate to protect the individual's safety and well-being, avoid harassment of the individuals by the press and others, and prevent undue embarrassment and other adverse consequences such as retaliation by Kelly's supporters, relocation, or loss of employment. So they really piling it on, and once again, just taking the route of the Northern District of Illinois. Of the Eastern District of New York, I'm sorry. So in addition, the government anticipates that Rishona's mother will testify about similar topics related to Rishona, including long-term abuse while she was a certain age. As a result, the government similarly moves to permit Rishona's mother, and I believe Rishona's mother name is Valerie, who has the same last name as Rishona, to testify using her first name only. And I think that this is just so funny because these people act like we don't know who they are already. So like, what are you protecting when people already know who you are? But, these are the semantics, that they want to go with. So the proposed protective order also contains a provision related to Lisa Van Allen, who will testify about, among other topics, contact that she had with Kelly and Rishona over the course of several years. So child, even to pile it on for real. The government seeks to preclude disclosure of Lisa Van Allen's address, names of family members, and place of employment at trial and during pretrial and post-trial proceedings in this case. Now, we could go along with this if these people themselves hadn't already put their information out there. But once again, we got to give the dramatic effect and make this seem like, it is like, oh my God, like this was a cult that was going on. So anyway, this case was charged in July 2019, and since that time, the case has garnered significant attention from local and national media sources. The same is true for Kelly's federal prosecution in the Eastern District of New York. In the Eastern District of New York case, the court granted the government's motion to exclude references to individuals' last names and other personal identifying information during the trial. In sum, a balancing of the risks to the individuals against the defendant's interest supported permitting the requested limitations. The individuals testified about humiliating and explicit acts of abuse, some of which took place when they were of certain ages. The same protocols are warranted in this case. So, remember we talked about setting a precedence, right? That, for the people that was like, he guilty and I don't care how they find him guilty. They can use whatever laws, whatever rules, blah, 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 that they want to. And so this is what we have been trying to tell you. When you go along to get along, then they start setting what's called precedence, where they can say, okay, well, this ruling happened in that case, so it applies to this case. It supports, us wanting to do this in this case. And yeah, it may be cute, if you hate this man and just want him in jail. But what happens when they start using these same rulings to impact your family members, your friends, people that that you think, oh my God, this person never would have done this. But now you sat back and allowed this to take place, to become rules and things that support this type of behavior by the government. And I have no problem with the government prosecuting somebody, but let's be fair about it. Don't just make up the rules as you go and stack the deck against the defendant so that they can't properly defend themselves. So then they go on to reference several court cases. But before I get into that, there's a note at the bottom of the page, and it says, as noted in the government's motion in limine number 4 below, it is unknown at this time whether there will be sufficient room for spectators to be seated in the courtroom gallery for this trial. If there are spectators in the gallery, the government requests that the court admonish any courtroom sketch artist present that there shall be no sketches prepared of the individual faces while they are testifying. It also may be appropriate to post notice of this order on the courtroom door. So now they're building their case as to why they're not going to let spectators in the courtroom. So pay attention. So several district courts have excluded mention of individual names at trial, citing the privacy interests of the individuals. United States versus Campbell, 7th Circuit, 2014, referencing individuals who testified at trial under their real first names. United States versus Nichols, February, and that was in the Northern District of Illinois, February of 2018. In trafficking case, protective order entered precluding reference to adult individuals' last names and requiring all documents disclosing the last name of any person to be filed under seal. United States versus Gardner, which was heard in the Eastern District of Michigan, September 28th, 2016. And then United States versus Thompson, Western District of New York in 2016, giving the anticipated explicit and sensitive nature of the evidence in the case, the government has a compelling interest in limiting identification of the individuals. United States versus Paris, the District of Connecticut, October 2007, excluding mention of adult and other victims' names, full last names at trial, as the government has a legitimate and substantial interest in protecting these witnesses from the likely adverse personal, professional, and psychological consequences of publicly linking their identities to their past lives as sex workers. As the Gardner court held, excluding evidence of the individuals' names is consistent with the Crimes Victim Rights Act, Title 18, United States Code, Section 3771A8, which states that an individual has the right to be treated with fairness and with respect for the individual's dignity and privacy. And then additionally, the government has an interest in encouraging victims, particularly victims of certain crimes, to testify by protecting them from some of the adverse consequences of their testimony. While the public has a constitutional right of access to criminal trials, that right is not absolute. Globe Newspaper Company versus the Superior Court for Norfolk County in 1982, a court can inhibit the disclosure of sensitive information when it is narrowly tailored to serve a compelling governmental interest. In this case, the exclusion of the individual's last names while otherwise allowing their testimony in open court is narrowly tailored to serve the interest in protecting the individual's privacy rights. C. Thompson, and then that was a ruling by a circuit court. And Thompson stated, the court cannot envision a protective order barring mention of individuals' full last names that is more narrowly tailored to serve the government's compelling interests. Excluding mention, and then another judge by the last name of Gardner stated, okay, and then this was, okay, excluding mention of an adult individual's last name at trial, explaining that use of the individual's full name would add nothing substantive to her in-court testimony that cannot be supplied by the use of her first name and first initial of her last name. For the reasons set forth, the government respectfully requests that the court grant the government's motion and one, permit the individuals and their mother and the individuals and one of the individual's mother to testify using their first names only. And so when they talk about the mother testifying, they're talking about Rishona, and then her mother, I believe her mother's name is Valerie. And so for those who were wondering, since the father passed away, Greg Landfair passed away last year, and we know that the reason that Rishona is supposedly testifying now is because they threatened to prosecute her parents if she refused to testify, which I think is a bunch of BS when you consider in the Eastern District of New York, the Clarys, who really should have been on trial, for even just for being poor parents, period. They were protected, their communications and everything. The government didn't even use those text messages that we now have, showing where Alice Clary and her poor behavior and parenting skills and pushing her daughter to go to this hotel room and all of that. They were left out of the case completely, right? Couldn't even talk about the parents, couldn't even use the parents in the defense or anything like that. But however, we did have Faith's mom come up there, because Faith's mom is going to ride or die. And speaking of Faith's mom, Kelly Rogers. So there's this person who keeps commenting on my videos by the name of Candy Johnson. And it seemed like I was on somebody else's video, and the people in the chat, it was a live stream, and the people in the chat were saying that whoever that Candy Johnson person is really Kelly Rogers. So I don't know for sure if it is Kelly Rogers or not, but look for her in the comments, because she be going off, okay? So anyway, it looks like Miss Valerie is going to be testifying, and that they're moving forward, and it just will be interested. I am really interested in hearing what Rishona and her mom have to say, and where is the culpability for the parents for allowing this to take place in the first place. So anyway, we are going to move on. It says, okay, so Valerie to testify using first names only, limit references to each of the individuals, and Valerie in court 2, their first names only, and 3, prevent public disclosure of addresses, full names of family members, or exact place of employment if any of the individuals and Valerie and Lisa Van Allen Now, okay, like I said, we already know who a lot of these people are, who their family members are, so take it at what it is. So the government further requests that the court enter the attached protective order that sets forth the government's requested relief. The proposed protective order supplements the existing protective order in the case, which contains several provisions regarding the disclosure of discovery materials produced in this case, including a prohibition on including any information marked as sensitive in any public filing in the court. And then there is a note at the bottom that says discovery related to individuals, including their full names and other identifying information, has been produced as sensitive material in the case. So 2, motion to preclude evidence of his sexual history. Okay, so for the reasons set forth below, defendants should be precluded from eliciting on cross-examination or otherwise introducing evidence or making arguments as to the sexual behavior of the individuals with individuals other than Kelly or others at Kelly's discretion. Now, this is real interesting because they're bringing in Lisa Van Allen to testify that she was doing things with Rashona. But he can't enter evidence discussing the promiscuity of these individuals. Quite interesting. So, A, the evidence is inadmissible under Rule 412. By its plain terms, Rule 412 bars evidence of an individual's history and predisposition in cases involving allegations of misconduct. The following evidence is not admissible in a civil or criminal proceeding involving alleged misconduct. 1, evidence offered to prove that any alleged individual engaged in other behavior, and 2, evidence offered to prove a victim's predisposition for liking to do things. So the purpose of the rule is to safeguard the alleged victim against the invasion of privacy, potential embarrassment, and stereotyping that is associated with public disclosure of intimate details, and to encourage individuals of misconduct to institute and to participate in legal proceedings against alleged offenders. Federal Rules of Evidence 412 Advisory Committee notes United States versus Cephas, which was a case heard in the 7th Circuit in 2012. United States versus Elbert, which was heard in the 8th Circuit in 2009. Thus, purpose is consistent with other provisions of federal law which provide that all crime victims have the right to be treated with fairness and with respect for their dignity and privacy. Consequently, Rule 412 is interpreted broadly and applies to all behavior of the victim before trial. United States versus Torres, 9th Circuit, 1991, whether offered as substantive evidence or for impeachment. Federal Rules of Evidence 412 Advisory Committee notes Rule 412 imposes clear limits on a defendant's ability to introduce evidence that an individual engaged in other behavior or has a propensity to engage in similar acts. In the context of criminal cases, the rule prescribes very limited exceptions to this inadmissibility. The court may admit the following evidence in a criminal case: A, evidence of specific instances of an individual's behavior is offered to prove that someone other than the defendant was the source of semen injury or other physical evidence. B, evidence of specific instances of an individual's behavior with respect to the person accused of the misconduct, if offered by the defendant to prove consent or if offered by the prosecutor, and C, evidence whose exclusion would violate the defendant's constitutional rights. So basically what this comes down to is that they're saying that because these people were of a particular age back in the 90s when all of this, 1990s, yes, almost 30 years ago, that all of this took place, that they were of a certain age. So it doesn't matter what their past behavior was. Like they could have been going through the neighborhood, giving it up to any and everybody. They could have been prostitutes on the street. It doesn't matter because they had not reached the age of consent. And so you cannot bring these things in because regardless of what behavior they had before, during, or after, the act that you were involved in with them would still be illegal based on their age. So it goes on to say the Federal Rules of Evidence 412B, if a defendant intends to produce evidence of an individual's behavior or alleged predisposition under one of these exceptions, the rule requires the filing of a sealed motion no less than 14 days before trial that specifically describes and states the purpose for which it is to be offered, with notice to the individual or her representative. None of the limited exceptions to Rule 412 apply in this case. Kelly is charged with enticing each of these individuals named in the indictment to engage in contact and acts with him repeatedly over the course of years. Here, any evidence of a person's behavior with anyone other than Kelly or others at Kelly's direction, as well as any evidence of any purported predisposition, would be wholly irrelevant to the charges against the defendants. The exclusion of evidence on these topics is thus appropriate under Rule 412. Then they cite United States versus Isabella, which was heard in the 10th Circuit in 2019. And once again, good people, these are these cases, that they use to then go back and build future cases. Prosecution affirming district court's decision to prohibit the introduction of evidence suggestive of the individual's predisposition and her previous activity with a male depicted in photos on her phone. B, the evidence is inadmissible under Rule 403. Even if evidence concerning the individual's conduct was relevant, it is not. Any probative value would be marginal at best and substantially outweighed by the dangers of unfair prejudice, confusion of the issues, misleading the jury, and embarrassing the victim. And it should be excluded pursuant to Rule 403. In particular, such evidence would provide for the substantial risk that the jury will question the individual's sexual morals and view them as untruthful because of their prior activities. For all of these reasons, any injury or evidence related to the individual's history is properly excluded under Rule 403. Number 3, motion to bar evidence and argument related to consent. That's what I was talking about a few minutes ago. Okay, so the government requests that the court prohibit defendants from introducing evidence and arguing that the individuals consented to engaging in activity while they were under Chicago's legal age of consent. It is well established that they lack the capacity to consent, and so contact with an individual is always without consent. United States versus Rogers, 8th Circuit in 2008, affirming the district's court's exclusion of consent evidence as irrelevant in a prosecution under Title 18 United States Code Section 2251A. United States versus Rapplinger, 8th Circuit, 2009. Because the district court was correct as a matter of law that consent is not a defense to the crimes charged, it was not an abuse of discretion to exclude the consent evidence. See also United States versus Keys, 7th Circuit, 2018, that the individual consents to engaging in prostitution is not a defense to the crime of trafficking an individual for purposes of prostitution. In Rapplinger, the defendant was charged with exploitation of an individual in violation of Title 18 United States Code Section 2251A and E, distribution of CP in violation of Section 2252A1, AA1, and B1, and possession of CP in violation of Title 18 United States Code Section 2252 AA5, B, and B2. The defendant agreed that consent was not a defense in the distribution or possession of CP charges. However, at trial, he sought to introduce evidence of the individual's consent to the exploitation charge. Specifically, the defendant sought to introduce evidence that the individual consented to engage in the behavior and lascivious exhibition. On trial, the Eighth Circuit rejected the defendant's argument that such evidence should have been admitted and concluded that because the district court was correct as a matter of law that consent is not a defense to the crimes charged, it was not an abuse of discretion to exclude the consent evidence. The Eighth Circuit further held that the jury was properly instructed that an individual may not legally consent to being exploited. The Ninth Circuit's decision in United States versus Dingra, Ninth Circuit 2004, is also illustrative. The defendant charged with enticement in violation of Title 18 United States Code Section 2422B proposed a jury instruction that would have required the jury to acquit him if it found that the individual induced him and was at least partially willing to engage in the alleged conduct. The trial court refused to give the instruction. In affirming the defendant's conviction, the Court of Appeals wrote, "The defendant's argument collapsed because he misconstrues the nature of liability under Section 2422B. His proposed jury instruction reflects this mistake. In effect, the defendant claims that entrapment by the individual ameliorates and inducement in his part. Again, this reading of the statute mistakenly changes the focus from the defendant to the victim. The individual's willingness to engage in the activity is irrelevant. In much the same way that an individual's consent to activity does not mitigate the offense of the statutory R word or molestation, so long as a defendant's actions constitute the act of persuading, inducing, enticing, or coercing an individual to engage in criminal activity. Section 2422B applies." So this is what I was talking about earlier, about the consent. Like, you can't say that a person consented if they were not of the age to consent. And then there was something else while I was reading that I said I was going to touch on, and it is eluding me right now, but I'm sure it will come back to. I was going to talk about the defense in the Eastern District of New York case. So this should be giving you guys a clear idea of why the defense had no case to put on, because the government had prohibited them from put any angle they wanted to try that case. They were prohibited from doing it because the government had made it impossible. They got Judge Ann Donnelly to rule on all these different motions of things that they couldn't talk about. They couldn't talk about the parents' involvement. They couldn't talk about, that these women came after them, that these women put themselves in these positions for whatever happened, that, you know, it was consensual, that all those arguments that they would have had went out the door. And then their witness list probably got cut short, because then now you're limiting people who had information that would support that, yeah, this person showed up with a fake ID, yeah, this person hounded him and, you know, did this or did that. Then those people were eliminated because they were prohibited from sharing the knowledge and information that they had about the case. And then, you know, in the Eastern District of New York, they prohibited including the parents. You know, they couldn't talk about the parents and what the parents did. And that's why that the transcript of the text message from Alice Clary wasn't entered into the evidence that was presented at the trial, because they had gotten Judge Dunley to rule that the parents, you know, weren't on trial, and so you can't talk about their parenting skills. And now we better understand why the defense was what it was. Now, I still think they could have put on a case. And I think that Jennifer Bongine is going to figure out how to put on a case. But those other attorneys were ill-equipped, hadn't been around long enough to be able to put all this stuff together. And so that's why they failed miserably, and the court set it up for them to fail miserably. So it goes on to say, in the United States versus Dye, which was heard by the Third Circuit in October 22nd in 2010, the Third Circuit rejected a similar argument. In that case, the defendant was charged with enticing someone in violation of Section 2422B and traveling interstate for the purpose of engaging in illicit conduct in violation of Section 2423B. At trial, he admitted to the conduct alleged, but argued that the government's evidence against him was insufficient because the purported individual, quote, was a seductress who had persuaded, induced, and enticed him, not the other way around. The Third Circuit rejected this defense. So just imagine somebody out there prostituting. So you're going to lose either way. You're going to lose. So then what the judges had to say, let's see, let me go back up here. Okay, the Third Circuit rejected this defense, and what they wrote in their response was, the defendant's hot to trot defense is especially troubling because its underlying premise is that it is possible for an individual to seduce a 36-year-old man, absolving the man of criminal liability for engaging in or attempting to talk to the individual or talk the individual into engaging in illicit activity. The defendant cites no case law, however, to support the notion that individuals who are by law unable to even consent to activity, United States versus Romeo, Third Circuit 2005, can quote unquote ask for it in such a way that it becomes legally permissible for adults to entice these individuals into escapades. In this case, consent is not a defense to the charges in counts 1 through 4 and 9 through 13 of the superseding indictment. Whether any of the individuals allegedly agreed to engage in the conduct with or at the direction of Kelly is irrelevant to whether Kelly is guilty of violating Section 2251A or 2422B. Therefore, evidence and argument related to the individual's consent is irrelevant and should be excluded at trial. This includes questions during cross-examination of the individuals about whether they consented to having sex with Kelly or others while they were of certain ages. Such questions would call for witnesses to make legal conclusions and should be barred. For For all of these reasons, the court should grant the government's motion to bar evidence and argument related to consent. The government will offer instructions on this issue in its proposed jury instructions to be submitted at a later date. Part 4. Motion to prevent the public display of CP videos during trial. The court should prevent the publication of CP video clips to the gallery during trial. There is no doubt that criminal trials are public events and that weighty concerns about the fairness and integrity of the proceedings require that criminal trials be open to the public. United States versus Curley, 7th Circuit in 1985. The presumption of openness in criminal trials is not absolute, however. United States versus Gupta, 2nd Circuit in 2012. The presumption of openness may be overcome only by the overriding interest based on findings that closure is essential to preserve higher values and is narrowly tailored to serve that interest. Press Enterprise Company versus somebody. That was a case from 1984, quotations omitted. Here, the overriding interest is the protection of Rishona, who is depicted in the CP that the government intends to introduce at trial. The Supreme Court has found that this creates a permanent record of abuse, and the very existence of that causes the individual continuing harm by haunting them in years to come. And that was from Osborne versus Ohio. Then they have notes at the bottom here. Note number 5, prior to trial, the government will submit the clip portions and any screenshots of the videos that it seeks to use for review by the court and defense counsel. And then 6, at this time, it is unknown whether there will be sufficient room for spectators to be seated in the courtroom gallery. If there are spectators in the gallery, the government requests that all monitors facing the gallery be turned around or otherwise turned off so that spectators cannot see the images being displayed on the screens. In addition, if there is to be an overflow courtroom where spectators can view the trial, the government requests that the monitors in any overflow room be similarly turned around or turned off while the images are being displayed during the trial. Now, okay, y'all. Have these videos not been circulating for 30 years almost? Now, I shouldn't say 30 years. What is that? 25 years. Haven't these videos been circulating? I mean, not saying that, they should show them in the courtroom. I guess it would be embarrassing to be sitting there with the video showing, but just this, okay, I'm not even going to say anything other than y'all claim. Now, I haven't seen the videos, don't want to see the videos, but y'all claim that the video's been on the market for years and continue to be on the market. And so I don't understand how there haven't been any injunctions against websites or individuals selling the videos if they are so sure that this is Rishona in the videos. And then I also find it interesting that of all the people that they have in this case, that they still are harping on those same videos, that there aren't any new videos. And then maybe there are new videos since there had all this conspiracy going on about the videos. And so maybe there are additional videos that Lisa Van Allen has turned over to Michael, the convict Michael Avenatti in this case, that he turned over to Kim Fox in the private room at the airport. But anyway, I just find it interesting that they want to take so much care of these videos that y'all claim have been out on the streets all these years. So anyway, they go on to say the individuals often write about their ongoing anxiety and fear that people who see them in public places will recognize them from the photographs that were taken of them as they were exploited. And then they talk about a book or an article or something that was written, and they put the website in here, and where they cite the website. Although individuals cannot control that these images exist, this court can prevent the images from being publicly displayed during trial. So the government has narrowly tailored its request to serve the individual's interests. The only accommodation that the government seeks is for the court to limit publication of the explicit videos to the jury and trial participants while avoiding publication to the gallery. The government is not asking for any limitation on testimony describing such images. Requests to limit publication are commonly granted. United States versus Trope, Northern District of Indiana, which was heard in August 31st, 2012. Limiting images to the jury and trial participants and finding that there is no particularly compelling reason why the public would need to see it in the gallery during trial, and it would be detrimental to the individual depicted therein to put their victimization on display. In United States versus Seatman, the court granted the government's motion to prevent the public display of clips during the trial in that matter. And I guess it would be pretty embarrassing to be sitting up there in the stand and then having to retell this story, which I think is just going to be so interesting. And the reason it is so interesting is because this particular government witness, according to blogger Tasha K, was putting money on his books while he was in Chicago. I'm not sure if she's still putting money on his books while he's in New York, but was still a part of his life leading up to these indictments coming down. And so I wonder if Jennifer Bongine is going to be able to point that out. Will she be able to introduce that information that, I don't know, it's just going to be really, really interesting to see how that unfolds. So then it goes on to say, further preventing the display to the public does not constitute plain error. United States versus Killingbeck, Second Circuit 2015, finding no plain error where even assuming that restricting the display of trial exhibits to the courtroom audience constitutes a partial closure. For Sixth Amendment purposes, the government presents substantial reasons for doing so, limiting the continuing harm of the individual. And then United States versus Boyle, 8th Circuit 2012, finding no plain error where district court permitted the government to turn off a monitor facing the gallery during the display of these images. And so I really, because I'm thinking if it really is what it is, then no, the people in the audience should not be watching it. Now that's my view. Now I guess they would want to watch to be sure and to confirm in their minds that it is who it is on the video. But other than that, I really don't see any value in the people in the audience watching it. So then we move over to number 5, which is government's intended evidence of polygraph examination. Now, child, I didn't know polygraphs were admissible in court. So anyway, it says, at trial, the government will present evidence about polygraph examinations that were administered for multiple witnesses who were involved in the recovery of videotapes produced by Kelly. Okay, so this is where Lisa Van Allen and her crew come through. So A, factual background. Okay, before I read that, there's a note at the bottom of the page. So note number 7 says the government is also aware of an oral motion of the government being granted in the following cases: United States versus Gabrielle, United States versus Norweathers, United States versus Berg, and United States versus Burns, and United States versus Conrad, but they don't tell us what the oral motions is about, so I'm not sure what that note is about. So anyway, in summary, count 5 of the superseding indictment alleges that between 2000 and 2019, Kelly and McDavid conspired with each other. Individual A, who I think we learned was a private investigator for the attorney, Ed Jensen, who was representing Kelly in the 2008 case. So individual A and others to conceal and cover up the existence of multiple videos depicting Kelly in contact with individuals. Superseding indictment count 5, 2 through 5. In approximately 2001, Kelly and McDavid learned that at least 4 of these videos, video 1, 2, 3, and 4, were missing from Kelly's collection. In order to conceal and cover up the existence of videos from investigators, Kelly, McDavid, and others agreed to collect the missing videos that depicted Kelly in contact with these individuals. It is alleged that Kelly and McDavid paid hundreds of thousands of dollars to this investigator, and then individual B, individual C, and individual D. So we know that, so A is the investigator, and we believe that B and C is, Damon Friar, and then the guy that Lisa Van Allen was dating, whose name always seems to elude me, but I've mentioned him in other videos, so you guys know who I'm talking about, the big guy. And then individual D, who we know is Lisa Van Allen. So in exchange for obtaining and returning multiple videos that they knew depicted Kelly engaged in contact with individuals. As a condition of being paid money for returning the tapes, the superseding indictment alleges that Kelly and McDavid directed, what is that man's name, y'all? Damon Friar, and then the other guy's name, his last name is Brown. Yule Brown? Is that his name? Yule Brown? Okay, and Lisa Van Allen to take polygraph examinations regarding whether they had returned all copies of such videotapes. So the indictment further alleges that at the direction of McDavid on Kelly's behalf, Brown and Van Allen took polygraph. Okay, so I guess they got the polygraph exam, like they didn't administer the polygraphs. Okay, so they're saying Kelly and his team did the polygraphs. Okay, that individual C and Lisa Van Allen, because we don't know who B and C, whether it's Brown and Friar or Friar and Brown, but we know that D is Lisa Van Allen, had returned depicting Kelly engaged in contact with Rashona and Lisa Van Allen, including whether there were additional copies of the videotapes. At trial, the government will call individual B, individual C, and individual D, Brown, Friar, and Van Allen, to testify about their involvement in the conspiracy to recover and return the tapes to Kelly and McDavid depicting Kelly's and Rashona. Brown, Friar, and Van Allen would testify about the communications that they had with the defendants about returning the tapes in exchange for financial compensation. They will testify about how, as a condition to receiving the promised payment, they were required to first take polygraph examinations about whether all the tapes had been returned to Kelly and McDavid. Oh, I know what I was going to say earlier. So y'all remember in the New York case how they had to have recital lessons with these witnesses. Remember Ariel, they said, had sat with the government for 60 hours to, memorize her testimony. So I'm wondering if they're going to do the same thing with these people, considering, we're talking 25 years ago. And like, do these people really remember what happened or what went down? I mean, I don't know. It's just weird to me that the government is allowed to do some of the things that they do. But I just wonder if for the past 2 years they have been working with these individuals to memorize the story that they are going to tell during trial, and what details to leave out and what details to add on to the story. So the government also plans to call on or more of the polygraph examiners to testify about their involvement in administering the polygraph examinations of Brown, Friar, and Van Allen. Okay, so they got the people that administered the polygraph, y'all. So through these witnesses, the government will introduce testimony and documents related to the polygraph examinations that were administered on behalf of Kelly and McDavid. The documentary evidence, which is described further below, is relevant to the charged conspiracy in that it demonstrates that the witnesses were subject to such examinations about the videotapes as a condition to their promised payments from Kelly and McDavid. For example, the government anticipates that Van Allen would testify that in 2007, she was required to take 3 polygraph examinations. Man, they really thought she was lying. Geared at determining whether she had returned all copies of a videotape. Okay, so the fact that these videotapes that resurfaced let us know that she lied and beat the lie detector, right? So I wonder if Bonjean gonna be why she had to take 3 lie detector tests, and then now we know she still lied and it didn't detect the lie. So anyway, that she took from Kelly that depicted Van Allen with Rashona, and then then Van Allen would testify that after passing the first 2 polygraphs, she received payments from McDavid and Kelly. In order to get the remaining money that she was promised by Kelly and McDavid, Van Allen had to take a 3rd polygraph examination. The government seeks to introduce documents related to Van Allen's polygraphs, including dated consent forms signed by Van Allen in which she agreed to take the polygraph examinations and release the results to Kelly's attorneys at the time, pre-examination interview forms completed by the examiner containing such general background information about individual D, and the examiner's notes listing the questions that he asked Van Allen during the polygraph examination. But I don't think this is new news about the polygraph. Seems like I've read before in old news articles that there were polygraphs that were taken. Now my thing is, why did the government let this go for so long? Because remember, all of this came out at the 2008 trial, but now they done turned around and waited and twisted and gathered new evidence to bring this thing back up and put her back into this case. So these documents are relevant to show the dates that the polygraphs were administered, who administered them, and who would receive the results of the exams. In particular, the questions that were asked during the examinations are relevant to establish the purpose of the polygraph examinations. As another example, the government plans to call individual C, who is either Brown or Friar, to testify about how Van Allen sent him a copy of the videotape that she took with Kelly containing the video of Kelly and Van Allen and Rashona. So while she wasn't charged with interstate commerce and all inter and intrastate commerce and all this other stuff. So after Brown or Friar received the tape, he was summoned to Chicago to meet with McDavid about returning it. Okay, so Brown or either Friar is expected to testify that before he left for Chicago, he made a copy of the full-length tape. Now, it seems like there is some criminality in this guy that he out here making copies of it and only brought a shorter snippet of the video with him to Chicago. And this sounds like this might be the Yule Brown guy. So according to him, once he arrived in Chicago, he provided the snippet to McDavid, who went into another room with Van Allen. When McDavid returned, he told individual C that he would have to take a polygraph examination and that he will testify that after he took the polygraph and failed, David instructed him to go home and get the original tape or else someone would come visit him. He understood McDavid's statement to be a threat. He will further testify that before he left that day, McDavid paid him $20,000 in cash as a down payment for going back to get the original for McDavid and Kelly. Okay, can we say that these are like the dumbest criminals? So the government anticipates that he would testify about the events that occurred after he returned to Chicago with the original tape. Specifically, he is expected to testify that he was required to take another polygraph examination about whether he had any other copies of the tape. According to him, he passed the second polygraph and McDavid paid him $80,000 in cash. The documents created as a result of the polygraph examinations, including the consent forms that he signed and the examiner notes regarding his administration of the polygraphs, confirmed that his trips to Chicago and meetings with McDavid and are direct evidence of the conspiracy to conceal and cover up the abuse. B, argument. In this case, defendants use examinations as a tool to further polygraph examinations as a tool to further their conspiracy to obstruct justice and recover the tapes of Kelly. During the conspiracy, defendants retained multiple examiners to administer the polygraphs to multiple witnesses in this case, many of whom were subjected to more than one polygraph. The evidence demonstrates how serious the defendants were about recovering the missing tapes and is admissible to show consciousness of guilt. So the government seeks to introduce evidence and testimony about the polygraph examinations for purposes wholly unrelated to the substantive correctness as of the results of the polygraph examination. The government will not elicit testimony from witnesses about whether the results of the test were scientifically accurate, because we know that it is not. The purported results are only relevant insofar as they provide important context as to 1, why McDavid required individuals to take multiple tests, and 2, why McDavid paid large sums of cash to individuals after it was reported that they passed the examinations. The government further represents that it will not use the results of the polygraphs to bolster the credibility of any witness and will not make any arguments regarding the scientific reliability of polygraph examinations at trial. Well, that is good to know, okay? Because we know that these things are not scientific reliable. If all we know, you Brown could have paid off the polygraph person and say, okay, man, I'm gonna break you off by 5 G's if you go ahead and say that I passed this test. So admission of the polygraph evidence for the limited reasons set forth above is permitted under Seventh Circuit law. The Seventh Circuit has given district courts considerable deference on the issue, indicating that the decision to admit polygraph evidence will be reversed only when the district court has abused its discretion. United States versus Resnick, 7th Circuit, 2016, internal quotations omitted. In Resnick, the government presented evidence that during the execution of a search warrant on the defendant's home, law enforcement asked the defendant to take a polygraph examination, and defendant refused to take one. In affirming the court's admission of the evidence at trials, the 7th Circuit reasoned that this case is not in the end about polygraph evidence. It is about evidence of a refusal to take a polygraph. The same principle applies here. The government is not seeking to use the results of the polygraph examinations for their scientific value or to bolster the credibility of any witness. Rather, as alleged in the superseding indictment, Kelly and McDavid used examiners to administer polygraph examinations in furtherance of their conspiracy to obstruct justice. It is also important to highlight that the offered polygraph evidence does not relate to polygraphs of any other defendants in the case. As a result, there is no risk that the jury could make adverse inferences about the defendant's credibility, as the government is not offering evidence that any other defendants took polygraphs. And then they cite United States versus Bowen, which was in the 9th Circuit in 1988, affirming exclusion of evidence that defendant took a polygraph under Rule 403 because even if the facts about an exam were admitted without the results, the jury would still be reasonably likely to infer that defendant failed the polygraph. In sum, evidence of where, when, how, and why the polygraphs of individual B, individual C, and individual D, Yule Brown, Damon Friar, and Lisa Van Allen were administered is probative evidence of the conspiracy charged in the indictment, including, for example, one of the alleged overt acts that McDavid, acting on Kelly's behalf, directed, Lord Jesus, I guess Friar and Van Allen to take polygraph examinations, and as such, this evidence should be admitted at trial. 6. Notice regarding introduction of the false records alleged in the superseding indictment. The government provides notice that it will seek to introduce certain false records alleged in Count 5 of the superseding indictment. First, the government provides notice that it will seek to admit a memorandum summarizing an interview of Lisa Van Allen that took place on or about July 26, 2007. This memorandum, which is not hearsay, is relevant to prove that McDavid and Kelly conspired to obstruct justice as alleged in Count 5 of the superseding indictment. Particularly relevant to the motion is the allegation in the superseding indictment that on or about July 26, 2007, Kelly and McDavid directed Lisa Van Allen to falsely deny that Lisa Van Allen and Kelly engaged in acts with Roshona, when Kelly and McDavid knew that Kelly had engaged in these acts with Roshona and Lisa Van Allen. As Kelly and McDavid intended, a false record, document, and tangible object was prepared based upon Van Allen's false statement. Count 5, the memorandum of Van Allen's interview, is the false document referred to in the superseding indictment. Okay. As set forth above, Van Allen was summoned to Chicago multiple times in 2007 in connection with McDavid and Kelly's efforts to collect contraband videos and impede the Cook County criminal prosecution in 2008. Van Allen was required to take multiple polygraph examinations to assure that Kelly and McDavid that she had returned the video she took from Kelly that depicted herself, Kelly, and Roshona engaging in acts while Roshona was of a certain age. Individual, and they're going with 14 here. So individual D is expected to testify at trial in this case that following her third polygraph examination on or about July 26, 2017, McDavid told her to meet with other lawyers and tell them that she never had sex with Roshona. Van Allen is expected to testify that McDavid waited in the hallway as she went in the room to meet with the lawyers and provided them with false statements as instructed by McDavid. A memorandum of interview dated July 26, 2007 was prepared documenting Van Allen's false statements. In summary, the memorandum states that Van Allen provided the following information. Between 1997 and 2006, Van Allen had sex with Kelly and multiple other females, all whom she claimed were of legal consenting age. Okay. So Van Allen knew Roshona and had spoken to her on numerous occasions. Van Allen never saw Kelly in a situation with Roshona, and that Roshona was never a participant in any encounter with Van Allen and Kelly. And then the other false statement that they claimed she gave was that she agreed to be interviewed by attorneys on July 26, 2007. Van Allen was not forced, threatened, or promised anything to participate in the interviews. So those are the things that they said that she lied about. So at trial, the government will question Van Allen about the memorandum and lay the foundation for the memorandum's admission into evidence. The memorandum should be admitted as the statements therein are not being offered for their truth. Quite the opposite. The government seeks to use this document as evidence that she was coerced by McDavid and Kelly to provide false information about her knowing Rishona and Kelly's abuse of Rishona. The government's evidence will further show that on or about July 26, 2007, Van Allen received a $30,000 payment from McDavid. In addition, the memorandum is not privileged. After the memorandum was prepared, Kelly's attorney at the time provided the memo to the assistant state's attorney assigned to Kelly's criminal trial in Cook County. The Cook County State's Attorney Office, in turn, provided a copy of the memo along with the correspondence from Kelly's attorney to the U.S. Attorney Office, and the memo has been produced to the defendants in this case. Second, the government provides notice that it will seek to admit a police report containing false information provided by Rishona during the Chicago Police Department's investigation of Kelly in 2000. As alleged in the superseding indictment, in approximately December 2000, pursuant to instructions that Rishona received from Kelly, Rishona falsified and caused a false entry to be made in a police report. When Rishona denied to law enforcement officers that Kelly engaged in a relationship with her, at trial, Rishona is expected to testify that Kelly began having contact with her beginning around 1997 or 1998, when she was 13 or 14, y'all. When Rishona was about 15 or 16, in or about 2000, certain government agencies began investigating allegations that Kelly was abusing her. Kelly instructed Rishona on how to act and what to say if she was questioned. In or around December 2000, law enforcement officers from the Chicago Police Department questioned her about contact with Kelly. During the interview with CPD, she falsely denied the allegations of Kelly's misconduct and documented that information in a police report. In summary, the police report states that law enforcement interviewed her, who stated that she had never been abused by Kelly and that any such allegations are untrue. At trial, the government will seek to admit the CPD report into evidence. Admission of this report is permissible as it is not hearsay and is being offered to prove allegations in the superseding indictment. For all of these reasons, the above described records should be admitted into evidence. Now, y'all, what they're doing here is that they know they're putting all this information into these indictments intentionally because they know that there are bloggers out here that are covering this case. They want to leak this information to the news media. So they want all of this to get out into the public so that the jury can, I guess, hear this information, even if the judge does not allow, like if Jennifer Bongine is successful in arguing that it shouldn't be admitted into the trial, they've already put the information out there. And so you may be saying, well, Tracy, why are you reading this indictment with this information? Because there are other people out there that's going to read it. So it's not like me not reading it and sharing it with you guys is going to undo it or conceal it. But they're being very strategic about what they are doing here by putting so much detailed information out in this motion. So we see y'all, Northern District of Illinois. We know what y'all up to. So number 7, government's notice of intent to admit direct evidence of crimes charged. As set forth in the superseding indictment, Kelly is charged with multiple crimes relating to his abuse and exploitation of 5 individuals over the course of several years, counts 1 through 4 and 6 through 13. The indictment further alleges that McDavid knew that Kelly was abusing these individuals and that Kelly made several tapes documenting the abuse, count 5. Kelly and McDavid went to great lengths to cover up the abuse, including paying large sums of money to witnesses to ensure that they would lie to law enforcement about the criminal conduct. In furtherance of Kelly and McDavid's conspiracy to obstruct justice, it is alleged in the superseding indictment that, quote unquote, Kelly used physical abuse, violence, threats of violence, blackmail, and other controlling behaviors against victims so that Kelly could maintain control over them, prevent them from providing evidence to law enforcement, and persuade them to continue to abide by prior false statements relating to his contact and acts with them and recordings of such conduct. At trial, the government will introduce testimony and evidence of the physical, emotional, and abuse that Kelly inflicted on each of these individuals over the course of several years. The individuals will testify about how Kelly used violence and threats of violence to control, manipulate, and isolate them, all as a means to coerce them to have sex with him and prevent them from reporting Kelly to the police. For example, the government expects that Rashona would testify that Kelly began hitting her. No, wait a minute. First, y'all say it happened when at 13, 14. Now y'all saying he was beating her up when she was around 17 or 18. Rashona will also testify about how Kelly isolated her from her family and friends and controlled her every move, including when she was allowed, who she was allowed to talk to. Okay, first of all, okay, let me keep reading. Okay, as another example, okay, well, now I'm going to say this right now because we're moving on to somebody else. Wasn't Rashona living with her parents? Shouldn't she have been living with her parents at this age? Or are they saying that she moved out of her parents' house and moved in with him? Because I don't understand how somebody controlling you when you living in the house with a whole nother individual. And when your father was working for this man, like still working for him. So, child, this testimony is going to be very, very interesting. So, as another example, another individual would describe the strict rules that Kelly had regarding who she was allowed to speak to and that she had to seek his permission before interacting with other men. So, here we come with the Eastern District of New York testimony. According to her, there was one instance where Kelly punched a man after he told her that he thought that she was cute. Oh, he out here beating up people, y'all. Child. Okay. In short, Kelly used physical violence and emotional manipulation to entice and coerce. Now, this is where the fiction really about to come in. To coerce the individuals to have sex with him. Thus, testimony about how Kelly hit or otherwise inflicted physical violence against the individuals is direct evidence of Section 2422B charges. So, evidence of Kelly's abuse is also direct evidence of the charged conspiracy to obstruct justice, which alleges that between approximately 2000 and 2019, Kelly used physical abuse, violence, threats of violence, blackmail, and other controlling behaviors against individuals so that Kelly could maintain control over them. So I guess this is where they're going to bring in the bad act witnesses, y'all. To prevent them from providing evidence to law enforcement and persuade them to continue to abide by prior false statements relating to his contact and acts with them and recordings of such conduct. As a result, Rashona's testimony about his physical and emotional abuse of her while she was an adult is also direct evidence of the Section 371 charge. Child, Rashona gonna have a whole lot to say. And then also, you guys were talking about Geronda Pace, some video that she had made on her IG where she was saying that she wanted to be done with all of this, but they're forcing her to come to Chicago to testify. And I think I had told you guys, so she's not a person in this case, okay? But she might be called as a bad act witness so they can get in the conviction in New York. So they're going to try and maneuver and manipulate that situation to bring in that information as if the world, doesn't already know about it. So we'll move on to number 8, motion for prior notice concerning Rule 608, impeachment. The government moves to bar each party from introducing evidence, including by asking questions on cross-examination under Rule 608, B, except upon prior notice to the court and the opposing party outside the presence of the jury. Rule 608B provides that specific instances of past conduct may be inquired into on cross-examination if and only if they concern the witness' character for truthfulness. By its very nature, impeachment based upon a witness' prior conduct that is not relevant to the matter at issue creates a risk of causing unfair prejudice to an opposing party. First, a party attempting to conduct such impeachment may erroneously believe that such impeachment is appropriate when it is not. The end result being that the impropriety of the impeachment is only discovered after the disparaging impeaching conduct is presented to the jury as part of an attorney's question. Second, even if some conduct may properly fall within the scope of Rule 608B, counsel may exceed any limitations on the scope to which such matters may be addressed on cross-examination. Third, depending on the nature of the past conduct raised by the examiner, the jury may not be able to completely obey the court's instruction to disregard the contents of an improper question heard by the jury. For these reasons, and to obviate any risk of unfair prejudice, the government asks that this court exercise its discretion to preclude the parties from pursuing any impeachment under Rule 608B unless outside the presence of the jury. The party has made a prior offer of proof concerning the alleged prior conduct. See Federal Rules of Evidence 611. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to 1. Make those procedures effective for determining the truth, 2. Avoid wasting time, and 3. Protect witnesses and from harassment of undue embarrassment. Procedurally, the government proposes that prior to cross-examination, the court should require each party to first notify the court and other parties at sidebar of its intent to impeach under Rule 608B. This procedure would ensure that any alleged prior bad acts are not improperly communicated to the jury before the court has the opportunity to determine whether such alleged prior bad acts are subject of proper impeachment under the rules. So basically, they want the defense to show them everything. Basically wants to see the defense's playbook and how they're going to question these witnesses so that they can object ahead of time so that they don't impeach the testimony of the witnesses. See how low down and dirty these people are. And this happens in courtrooms every day all over this country, how they just be stacking the deck against defendants. So number 9, motion to preclude argument or evidence designed to elicit jury nullification. So now they're going to show us how they're going to set the jury up, stack the jury, y'all. So it says the government moves this court to preclude the defendant from arguing or otherwise presenting evidence or pursuing lines of inquiry designed to elicit jury nullification. It is well settled that it is improper for a defendant to suggest in any way that the jury should acquit defendant, even if it finds that the government has met its burden of proof. Yet, the government will tell the jury, you can find somebody guilty if we didn't meet the burden of proof, aka Sonia in the Eastern District of New York case, where the jury found that the lady was not credible, but yet y'all still trying to say that y'all had sufficient evidence to prove that she was guilty, but the jury just didn't pick up on it, and therefore her testimony should be considered in the sentencing guidelines. See how dirty the government is? Ooh, child. So it says, see United States versus Laguna, which was heard in the 7th Circuit in 2012. Court held that district court properly found that evidence offered by the defendant was irrelevant and served to only confuse the jury or invite the jury to acquit, even if the government satisfied each element of the offense. United States versus Perez, 7th Circuit, 1996. An unreasonable jury verdict, although unreviewable if it is an acquittal, is lawless, and the defendant has no right to invite the jury to act lawlessly. Jury nullification is a fact. Because the government cannot appeal an acquittal, it is not a right even of the jury or of the defendant. United States versus Sepulveda, which was heard in the First Circuit in 1993, holding that the court may block defense attorneys' attempt to serenade the jury with the siren of nullification. Therefore, the defendant should be precluded from presenting argument or evidence designed to elicit jury nullification. Okay, so the government cannot anticipate each form of potential jury nullification argument or evidence. The government moves to exclude the potential areas noted below, all of which are irrelevant to the elements of the crimes charged, as well as any argument or questioning, no matter what its form, that, in effect, would encourage a jury to acquit under any circumstances, regardless of the applicable law or proven facts. United States versus Anderson, 7th Circuit, 1983, quoting United States versus Doherty in D.C. Circuit, 1972. A. Motion to preclude argument or evidence concerning potential penalties faced by defendant if they are convicted. The government moves the court to preclude defendants from introducing evidence, making argument, or otherwise mentioning the potential penalties faced if convicted. For one, the Seventh Circuit's pattern criminal jury instructions include an instruction specifying, in deciding your verdict, you should not consider the possible punishment for the defendant. If you decide that the government has proved the defendant guilty beyond a reasonable doubt, then it will be my job to decide on the appropriate punishment. Pattern crime jury, criminal jury instructions 408, 2020 edition. Additionally, the Seventh Circuit has stated that arguing punishment to a jury is taboo. United States versus Richardson, 7th Circuit, 1997, vacated on other grounds. See also United States versus Lewis, 7th Circuit, 1997. The practice of informing juries about the sentencing consequences of their verdicts is strongly disfavored. United States versus McKenzie, 7th Circuit, 1991, holding that while the Sixth Amendment requires that a jury determine questions of guilt or innocence, punishment is the province of the court. Argument and evidence concerning punishment are improper because the law is well stated that the potential penalty faced by a defendant is irrelevant to the jury's determination of guilt or innocence. Shannon versus United States, 1994. It is well established that when a jury has no sentencing function, it should be admonished to reach its verdict without regard to what sentence might be imposed. Okay, so then they go on and quote several other cases. I'm not going to, and it's becoming very redundant. And it makes no sense when you consider that he's getting sentenced in the Eastern District of New York case in a couple of weeks. In 2 weeks, he's going to be sentenced. So the jury already know that he's facing whatever, a life sentence. The jury is already going to know that, you know, he could possibly get 25 years to life in the Eastern District of New York. So why they feel the need to go on and on about this as though telling the jury that the person is facing life in prison might somehow make the jury not want to find him guilty. Now, what they need to be concerned about is the fact that the jury already know about a previous case. And in that case, they might say, well, dang, we just piling on. What's the purpose of going through this exercise when you already found him guilty and are planning to sentence him to 25 years to life? So that could be their bigger struggle. So then they go on to B, and it says motion to preclude allegations of outrageous government conduct. Well, it should be included. So the government moves to exclude evidence of how we manipulate things to get I have to laugh at myself. The government moves to exclude evidence or arguments by counsel of outrageous government conduct, aka how they manipulate the laws and use all these prior cases to get the judge to rule on their behalf and in their favor in order to secure a conviction. So you're already demonstrating outrageous conduct just by the very nature of these motions that you have filed, where you are totally dictating how this trial is going to be run. But anyway, the Seventh Circuit repeatedly has held that the outrageous government conduct is not a defense in this circuit. United States versus Stallworth, United States versus Sherman, United States versus Boyd, outrageous governmental misconduct is no defense to a criminal charge, and the jury should not be exposed to irrelevant allegations of this sort. Furthermore, this circuit held that the issue of government misconduct was a matter of law for determination by the court. The issue of government misconduct is not an issue for the jury. United States versus Switek, 7th Circuit, 1987, noting that every circuit which has considered the issue has held that the issue is not a jury question, citations omitted. Yet there is a tendency in criminal cases to try some person other than the defendant and some issue other than his guilt. United States versus Griffin from the Northern District of Illinois in 1994. The thrust of the defense in these types of cases is this: the prosecution was not nice or could have done it better, and so the jury ought to acquit, whether or not guilt has been proved beyond a reasonable doubt. In the face of the tendency to interject themes of government misconduct into a defense strategy, courts routinely have granted motions in limine to bar defendants from presenting evidence or making arguments to the jury suggesting that they should be acquitted because the government engaged in misconduct in course of the investigation. So basically, y'all, they don't want Bonjean to get up there and say how they threaten and harass these people into testifying and that they threaten to arrest and charge Rashona's parents with conspiracy and all that other stuff if she didn't get her butt up there and testify and say that that was her in that video. So that's basically what they talking about here, y'all. Boy, the United States government is something else. And I guess that is why the United States has like the highest incarceration rates in the world, because they try to be doing the most. So then they quote some other cases, granting motion in limine to preclude evidence which is not relevant to defendant's guilt, but is designed only to persuade the jury that defendant should be acquitted because the government engaged in misconduct during the investigation. Accordingly, the government moves to bar the defense from introducing evidence or argument of outrageous government conduct. That's when you know you're guilty, when you got to write in a motion, like, Judge, please don't let them tell the jury about the tactics that we use to bring this case and how we're preventing them from putting on a proper defense to the jury, because then the jury won't find in our favor. Like, that's basically what they're saying. So C, motion to preclude argument and evidence regarding the government's motivation in investigating and prosecuting the case. Boy, Jennifer Bonjean is probably in California just seething. She probably can't sleep at night after reading this foolishness that these people done put out here. So the government moves to preclude evidence or argument by defense counsel regarding the government and the officers and agents' motivation for investigating or prosecuting this case. This includes, but is not limited to, arguments that the federal prosecution of defendant for CP offenses after Kelly's acquittal in Cook County Circuit Court is vindictive or otherwise improper. Now, this let y'all know that they be watching these videos and reading these blogs, right? That they know what people saying about them, okay? And plus, they probably know because several people have said that, regardless of all the allegations against Kelly, that a lot of people in Chicago still love him. They still support him. And so I think they put these rules in place for these people because they don't want them people to be like, oh, hell no, y'all doing the most. Like, we gonna find him innocent. Anyway, Kelly's acquittal in Cook County Circuit Court is vindictive or otherwise improper. Evidence bearing on the government's decision to prosecute is extraneous and collateral and thus excluded from trial. See United States versus Johnson, 7th Circuit, 1979, affirming the exclusion of evidence offered to show that the indictment was a political instrument. United States versus Clay, 8th Circuit, 2010. Selective prosecution of a criminal defendant is not an issue for the jury to decide. Further, the government moves to preclude the defense from arguing or eliciting evidence regarding the mental state, subjective intentions, or motivations of the investigating officers and agents. It is well settled law that inquiries regarding the subjective intentions or motivations of a government agent are irrelevant to determine the factual guilt or innocence of the defendant. United States versus Golden, 7th Circuit, 1994. Even in the context of entrapment defense, it was proper for the trial court not to allow the defense to mount an inquiry into the mental states of the investigating officers since such evidence was irrelevant. Accordingly, the government moves to preclude evidence or argument by the defense regarding the government's and the officers' and agents' motivations for investigating or prosecuting this case. And then they may be getting this because you guys remember Kim Fox when she got up there and made her emotional plea and put out that damn 800 number. She, admitted that she was a victim of abuse. And so basically her bringing that case was emotional, and it was vindication for her abuse that probably she has never uttered the name of her abuser in her lifetime, and therefore that person, got away scot-free. And so they basically don't want y'all to know about, these agents and officers who may have experienced some type of abuse in their past, or who may have been upset or angry that he was found not guilty in 2008. So they don't want any of that to come out, y'all. They don't want the jury to know about any of that. So motion to preclude argument and evidence of selective prosecution theory. Similarly, defendants should be precluded from introducing evidence or arguments seeking to present a theory of selective prosecution before the jury. During the trial, the government intends to call witnesses who, for example, participated in the conspiracy to receive the videos. The government anticipates that defendant may argue that some of these witnesses may have been engaged in unlawful receipt of the videos and have not been charged with any criminal offenses. Pursuant to Federal Rules of Evidence 401 and 403, such information is irrelevant and unfairly prejudicial. How is it unfairly prejudicial that you letting people that committed crimes get away with committing the crimes because it suits your narrative and benefits your case? How is that? Yes, it is unfairly prejudicial. I take that back. It's unfairly prejudicial to the defendant and your by any means necessary prosecution of this case. So indeed, in United States versus Young, 7th Circuit, 1994, the court granted on relevancy grounds the government's motion to preclude the defendant from introducing evidence that another individual who had been arrested with him was not charged. In so ruling, the Young court noted that the primary issue for the jury was whether the government met its burden of proof as to the defendant's knowledge, and whether or not another individual was criminally charged did not make the facts related to the defendant's knowledge and participation in the alleged crime more or less probable. See also United States versus Abad, 6th Circuit, 2006, observing that the defense of selective prosecution is a matter that is independent of a defendant's guilt or innocence, so it is not a matter for the jury. In the same vein, defendants should be precluded from making legally irrelevant and prejudicial. You doing that, Kate? Okay, in the same vein, defendants should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of these damn wayward children, okay? And to prove the offenses alleged in the superseding indictment, the government expects to present evidence that some of these people spent a substantial amount of time with defendants, and that defendants may try to deflect the blame for their criminal conduct by offering evidence that the parents knew or should have known about what their damn daughters was up to. They should have. They should have, because trust me, if I was gone from the house this long at this age, my mama, I remember, listen, this kind of household I grew up in, my mama knew I was coming in late, right? My mama used, and this is when I was an adult. This is when I was like 18 or 19, y'all, an adult. Because heaven knows I wouldn't dare be trying to stay out the house past certain times. Like if we went to a high school basketball game or something like that, trust me, I had my mama car back at that house by 11 or 11:30, right? Or she probably was coming looking for me. But when I was 18 or 19 years old, my mama used to sleep on the sofa to try to catch me coming in the house. Now, y'all know the clubs didn't close till like 2, 3 o'clock in the morning. And then we went to a club over in Tampa. The club might have stayed open to 6 o'clock in the morning. But when my mama told me she wanted her car back in that driveway at a certain time, that's what she meant. And child, let me tell you something. My job, I used to have to be to work at like 6 o'clock in the morning. This job I had at a nursing home. And so sometimes I would just stay out all night and then sneak in the house at like 5:30, take a shower, get dressed for work, and leave and go to work. So my mama started sleeping on the sofa so she could catch me coming into the house, right? Why I used to crawl through my bedroom window to get in the house. I was like, I would look through the blinds and see my mama sleep on the sofa. Now, my daddy done gone to bed. He like, child, whatever, she grown. Why are you stressing yourself out? You can't stop her from doing whatever she doing. So I used to climb through that bedroom window as an adult when I could have just got my own apartment and did whatever it was I wanted to do. So the fact that these parents had people at the ages that they're claiming in this indictment and didn't care where their kids were or what their kids was doing is a testament to their parenting. And yes, they should be held accountable. But according to the government, we don't care if parents are not concerned about where their kids are and what their kids are doing. But we will send them to jail for using the wrong address in order for their kids to go to a better school. We will send them to jail for having to work 2 jobs, in order to pay the rent, and they leave the 12 or 13-year-old home to take care of the 8 or 9-year-old. Now, we will put them in jail for that. But when it comes to your children running around with grown men doing things that they have no business doing, we won't hold you accountable for that. That is not your fault. That is not your promise. And it was a problem, and it was not your duty to know if your child was skipping school for 6 weeks so that they can go sit in on a trial about an adult nature none of that matters to the government. But child, try to do something illegal to benefit your child, and they're gonna be on your, they're gonna have their foot on your neck, okay? So anyway, it goes on to say defendants may further assert that to the extent the parents knew or should have known about the relationships with Kelly, the parents thereby consented to such relationships. Such evidence has no legal bearing as to the offenses with which defendants are charged. Indeed, consent by either the parents or the individuals is not a defense to such charges. Defendants may go so far as to argue that the parents or the individuals were responsible for or aided and abetted in the crimes. Such arguments are legally irrelevant and would only serve as a distraction to the jury. Okay, but the jury needs to know, because if the jury has any common sense, the jury should be sitting there saying, where were the parents? And were the parents, and now listen to this. We're talking about somebody who was like up and coming in their career, you know, famous, known to the community, making millions of dollars, making music. The jury should be sitting there wondering, did the parents profit from this? Did the parents turn and look the other way because they were benefiting, because they were getting their rent paid, because they were getting new cars or whatever they're claiming what was going on? Because either the parents just wasn't there, or the parents were benefiting by telling their child, okay, well, go get some money. Tell them you need, $1,000 for this, or, I need some help with my rent. I need a new car. Like, was the parents doing all that? Because if I was the jury, that's what I would be sitting there wondering, like, what the hell were the parents doing when all of this was taking place? And not only what was the parents doing, what was the school system doing? Because I know here where I live at, you miss more than 2 or 3 days from school. You miss school longer than a common cold would keep you out of school. And them people will call your house, okay? And I told y'all in another video where my daughter had to skip school one day, and the principal called me and was like, Miss Darity, can you call your child and tell her to get back on this campus? We saw her leaving, okay? And I had to call my daughter and be like, why are you skipping school? Like, where do you think you're going? Like, that's the kind of parenting that I grew up on, and that's the kind of parenting I used in raising my children. These parents obviously didn't have these type of skills, and it would just be interesting to know who these parents are, where they are now, and what they think about this whole case going on. Like, do they support it? Are they sitting there saying, "The child don't be implicating me in this mess. Leave my name out of it"? Okay, so I'm wondering what the parents are saying today. Okay, so they end that section with, for all of these reasons, the government moves to preclude evidence or argument by the defense regarding any theory of selective prosecution. So number 10, motion to preclude discovery requests or commentary regarding discovery in the presence of the jury. So the government moves the court to preclude the parties from requesting discovery from witnesses or opposing counsel, moving the court for such discovery, or otherwise commenting on discovery matters in the presence of the jury. Such requests in front of the jury may distract the jury or create the impression that one side has suppressed information as a means of seeking an unfair advantage. Not that one side has suppressed, that the government side has suppressed, because y'all the only ones that's trying to suppress information that I can see. So the United States versus Gary, which is heard in the Northern District of Indiana in March 2010, granting government's motion to preclude the defense from requesting or commenting on discovery in the presence of the jury. See also Thompson versus GlenMed Trust Company, 1996. Rather than focus on the issues in the case, the jury may instead be misled by the irrelevant side issues of the discovery process. Therefore, the court will not permit either party to refer to the discovery process in the presence of the jury at trial. As such, the government asks the court to prohibit either party from raising discovery issues in the presence of the jury. The appropriate time to raise such issues would be at a sidebar or while the jury is not in the courtroom. I think they've been watching too many television show, courtroom television shows, because we see that all the time on Law and Order and All Rise and all these other type court, shows where they show crimes and then the courtroom process. And they be getting up just raising all kind of objections, and you'd be like, okay, is this happening in a real courtroom? Because I don't think they're supposed to be doing that. So I don't know what the relevancy was for the government to be putting that motion in there, unless they know how Jennifer Bonjean operates in the courtroom, and maybe some of these things that they're calling out are trying to dampen her defense and how she conducts herself in court, because maybe she be in court saying like, okay, I didn't get that discovery, judge. Like the government raises an issue and then she jumps up and says, objection, Your Honor, that was not in the discovery. I need a copy of that. So maybe they're trying to curtail her courtroom tactics and try to suppress and silence her in the courtroom with some of the stuff that they are entering. So number 11, motion to exclude evidence or arguments regarding the constitutionality of the statutes criminalizing the production and receipt of CP. Arguments pertaining to the constitutionality of the statutes criminalizing CP offenses are wholly irrelevant to the indictment in this case and do not affect the Supreme Court's and the Seventh Circuit's unequivocal rulings that the First Amendment and the Commerce Clause do not protect CP. They just going all out. Rejecting a First Amendment challenge and upholding the constitutionality of laws prohibiting the possession and viewing of CP. 7th Circuit 2000, rejecting a Commerce Clause challenge to a conviction for possessing CP. For these reasons, the government moves to preclude defendants from introducing any evidence or argument regarding the constitutionality of the statutes criminalizing the production and receipt of CP. These damn people are crazy. Whoo, child. So they don't want them to bring up rulings by the Supreme Court that challenges the constitutionality of criminalizing the production of CP, because they are basically going to bring up the fact that these videos are all over the internet to this day. Oh my gosh. So number 12, motion to preclude argument or evidence of non-pertinent traits of defendant's character. The government moves the court to exclude all evidence offered by defendants of their lawfulness and or non-corrupt conduct, except reputation or opinion and evidence offered by character witnesses strictly in accordance with the limitations of Federal Rules of Evidence 405A. Other than testimony from character witnesses fitting within the narrow confines of Rule 405A, no such evidence is admissible. Rule 404A1 precludes the admissibility of evidence of a person's character or character trait to prove that on a particular occasion the person acted in accordance with the character or trait. What? 401A1 Rule 404A2 directs in relevant part that defendant may offer evidence of the defendant's pertinent trait. Pursuant to this rule, only pertinent character traits of defendants are admissible, and all non-pertinent traits are inadmissible. For example, in an effort to distract the jury from the charges at issue, defendants may seek to call witnesses to testify that on particular prior occasion, defendants followed the law or otherwise behaved as lawful members of the community. Any evidence or argument of this sort is inadmissible, and the court should exclude it. The law is clear. Evidence that a defendant acted lawfully on other occasions is generally inadmissible to prove he acted lawfully on the occasion alleged in the indictment. United States versus Reed, 7th Circuit, 2012. Also see United States versus Hendrick, 7th Circuit, 1990. Proof that a defendant acted lawfully on other occasions is not necessarily proof that he acted lawfully on the occasion alleged in the indictment. To hold otherwise would be to eviscerate the carefully drafted limitations of Rule 405, which forbid proof of good character through evidence of specific acts where character is not an element of the charge or defense. Like Rule 403, Rule 405 is intended to prevent the series of wasteful mini-trials which would inevitably ensue if defendants are allowed to introduce irrelevant testimony of non-pertinent traits of character. Accordingly, the government moves to bar defendants from presenting argument or introducing evidence of character traits of defendants that are non-pertinent to refuting the elements of the offenses for which they are charged. So, for those of you that were asking about the Eastern District of New York and why there were no character witnesses, this explains why. Because they say that just because you knew Miss Brown next door to be a good mother and a good provider for her children has nothing to do with the fact that she physically abused her children. So that's basically what they're saying. So let me go back up here because there was a note on the previous page. It says, note number 8, even evidence offered under Rule 405A cannot include specific instances of good conduct. It is limited to a description of the subject's reputation or to a brief statement of opinion without support from specific instances of conduct. See Advisory Committee notes to Rule 405. The rule contemplates that the testimony of specific instances is not generally permissible on direct examination or an ordinary opinion witness to character. Opinion testimony on direct in these situations ought in general to correspond to reputation testimony as now given, i.e., be confined to the nature and extent of observation and acquaintance upon which the opinion is based. Okay. So then number 13, motion to preclude defenses of alibi or unavailability and mental defect. Damn. Whew, child. Rules 12.1 and 12.2 of the Federal Rules of Criminal Procedure require that a defendant provide the government with notice of the following defenses. 1. An alibi or similar defense that the defendant intends to raise, including any defense asserting the defendant's unavailability on or near the dates named in the indictment. Why? So y'all can change the dates like they did in the Cosby case. So the woman swore for God that it was August 1974 when Bill Cosby took her to the Playboy Mansion, right? So then the Cosby legal team, aka Jennifer Bongine, goes to the Playboy Mansion, have them pull the records for the entire year of 1974, which proves that this lady was not at the Playboy Mansion at all in 1974. So then what does she do? Come back and say, oops, I made a mistake. It really was 1975. And the judge allowed it. So they basically want this information so then they can go back and have the witnesses change their dates and that type of information. Because they probably don't have any evidence or proof that this person was at his house or at his apartment or at his studio on these particular dates. They're just going by what the people are telling them. So on or about August 2nd, 2019, the government sent letters to defense counsel requesting notice pursuant to Rules 12.1, 12.2, and 12.3 of each of these defenses. The defendants have not notified the government of their intent to raise any such defenses. The government thus requests that the defendants be prohibited from introducing evidence or argument relating to such defense at trial. Now, how are you going to do that when the lady just took on the case recently? Oh my God, the government is so dirty and low down. They are some low down, dirty dogs, y'all. So 14, motion to preclude defense counsel from defining the term reasonable doubt. The government moves the court to order the defense not to attempt to determine or define the term reasonable doubt during opening statement or closing argument. The term reasonable doubt should not be defined by the trial court or counsel. United States versus Anderson, United States versus Reynolds, 7th Circuit 2002, and the other one was 1995. That is because any attempt to define the term presents a risk without any real benefit. That is, any definition of the term often leans toward misleading refinements that weaken and make imprecise the existing phase. Excuse me. Reynolds, internal quotations omitted. See also Anderson. Government argument was proper because it was invited by defense counsel's own improper attempt to define the reasonable doubt standard. United States versus Blackburn, 7th Circuit, 1993, noting that definitions of reasonable doubt have a likelihood of confusing juries more than the simple words themselves. For these reasons, the 7th Circuit has held that it is improper for attorneys to attempt to define the term reasonable doubt. United States versus Thompson, 7th Circuit, 1999. See also United States versus Clancy, 1999. In the 7th Circuit, United States versus Bruce, 7th Circuit, 1997. United States versus Alex Janals and Company, 7th Circuit, 1993. It seems simple enough. We admonish counsel, do not define reasonable doubt to a jury. Committee comment to 7th Circuit. Okay, these people just had too much damn time on their hands when they was writing this nonsense up. So number 15, motion to allow government to recall the case agent during its case in chief. What? The government respectfully requests permission from the court to recall the case agent, a special agent from Homeland Security Investigations, during the course of trial so that testimony can be presented to the jury in an orderly and understandable manner and in a manner most effective for ascertaining the truth. What they're really saying, as we learned from the Eastern District of New York, is that they're going to bring in these Homeland Security agents to confuse the hell out of the jury. Because when I tell you, those people got up there talking in all that technical jargon and just running their mouth on and on and on, that you forgot about the evidence that they called themselves certifying in the trial, because you had no idea what they were talking about and you forgot why they were even up there talking. So they're basically going to pull those shenanigans also. So this court has substantial discretion to determine the mode and order of interrogation. United States versus Vasquez, United States versus Puckett, upholding district court's decision to allow government to recall law enforcement witnesses so the evidence could be presented in chronological order. Federal Rule of Evidence 611A provides in part, the court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective for determining the truth and avoid wasting time. 611A, the procedure of permitting witnesses to testify in episodic or chronological order, has been approved in complex conspiracy cases. United States versus Jackson, 7th Circuit, 1977, United States versus Butera, 11th Circuit, 1982. So what they're saying there is the agents might be testifying, excuse me. So you remember in the Eastern District of New York, they would bring people up to testify that had nothing to do with the next witness. So that's basically what they're saying, is that the investigators might come up there to testify, and it might have nothing to do with the person who just left the witness stand or the person who is about to take the witness stand. So they're just going to create this ball of confusion for the jury so that they don't know what the hell was talking about, but that they assume because these are people from Homeland Security that they're honest and they're telling the truth. But as we saw with the Keith Raniere case, they're now saying that the Homeland Security agents were falsifying documents and planting evidence. on this man. So we can't really trust them either. So because the government intends to introduce, to the extent possible, evidence related to the conspiracy, which spans almost 20 years, and the substantive exploitation charges chronologically, the government anticipates it will need to recall the case agent to testify about, among other things, voluminous bank and financial records, other business records from dozens of sources, and multiple videos pertaining CP. While the government will attempt to limit the number of times it recalls the case agent as best it can, requiring her to testify only once would necessarily require the government to cover a broad number of topics out of chronological order in a fashion that would likely confuse the jury. Okay, so I guess they're saying that they're not going to do what the Eastern District of New York did. Okay, so I stand corrected. They say that they're just going to keep calling Homeland Security up there to present information as the witnesses are testifying. So I guess that's a better way of doing it, child, because they really had us very confused in the Eastern District of New York. So accordingly, the government respectfully requests that the court permit it recall the case agent to testify to the relevant episodes of the government's investigation. The government further proposes that after each instance of direct examination, the defendants be permitted to cross-examine the witness fully about any and all matters the witness testified about during that particular direct examination, so as to ensure a full and fair cross-examination. 16. Motion to admit business records pursuant to Federal Rules of Evidence 803C and 90211. Under Federal Rule of Evidence 90211, certified copies of domestic business records are self-authenticating if the party offering the records provides the adverse party written notice. Oops. I lost my pace, y'all. Y'all knew it was going to happen, right? That eventually this thing was going to jump on me. So let me get back. Okay. Let's see. Records are authenticating if the party offering the records provides the adverse party written notice and allows the adverse party to inspect the exhibit and certification, allowing the party to challenge the authenticity of the records. Under Federal Rule of Evidence 803.6, the records are an exception to the hearsay rule if following conditions exist. A. The records were made at or near the time by or from information transmitted by someone with knowledge. B. The record was kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. C. Making the record was a regular practice of the activity. D. All these conditions are shown by the testimony of the custodian or of another qualified witness, or by a certification that complies with Rule 902.11 or 12, or with a statute permitting certification. And E. The opponent does not show that the source of the information nor the method or circumstances of preparation indicate a lack of trustworthiness. The Seventh Circuit has consistently upheld the admission of business records through business record certifications pursuant to Rules 803.6 and 902.11. See United States v. Green, 7th Circuit, 2011, United States v. Cleansing, 7th Circuit, 2003, holding that admission of pre-certified business records under Rules 803.6 and 901.11 does not violate the Confrontation Clause because the records have sufficient guarantees of reliability. United States versus Ellis, 7th Circuit, 2006. The 7th Circuit upheld the admissibility records through the use of Rule 902.11 certifications in light of Crawford. And then there was a note number 9 at the bottom of the previous page. This motion constitutes written notice to defendants that the government intends to rely on business records certification for the identified records. The government moves the court, hold on a second, to find, pursuant to Federal Rule of Evidence 104, that the records at issue are authentic business records within the meaning of Federal Rule of Evidence 8036. Rule 104 authorizes the court to determine in advance of trial preliminary questions concerning the qualification of a person to be a witness, the existence of privilege, or the admissibility of evidence. This rule applies to all preliminary determinations, including the question of whether documents fall within the business records exception to the hearsay rule. See United States versus Casvin, 7th Circuit, 1985, affirming trial court's preliminary determination pursuant to Rule 104 that business records were admissible pursuant to Rule 8036. The government intends to introduce a variety of business records through certifications, including the records of state agencies, financial institutions and companies, and hotel and other travel records. Government Exhibit 1 is a chart of business records for which the government intends to rely on business records certifications under Rule 8036 and 902.11. The business records certification for records identified in the chart have been previously produced to defendant in discovery. The government will send them to defense counsel again under separate cover. The chart in Government Exhibit 1 also identifies the business records that are associated with each certification. The underlying business records have all previously been produced to defendant in discovery. The government intends to produce selected portions of the business records identified in the chart at trial. Additionally, the government may supplement this notice as additional business records certifications are received from business custodians of records. Admission of these documents through 902.11 certification will save the parties, the court, and the jury members significant time and resources, as the certifications will obviate the need for live witness testimony from several witnesses. Because the business records from the entities listed in Government Exhibit 1 and their accompanying certifications fall under Federal Rules of Evidence 902.11 and 8036, the government respectfully requests that the court find under Rule 104 that the identified business records fall within the business records exception to the hearsay rule. And so basically, I think what they're talking about is like bank records, LLCs, that type of stuff. You like proving that, oh, he did have a bank account at, Bank of America, and that part of the evidence might be that, how they keep talking about the checks that he wrote to Rashana, for $1,500, him turning over the Yukon, the truck or something that he gave her or helped her buy, that instead of bringing in people from, the tag office, the DMV, to say, yeah, this title was transferred, they'll have the certified record that the title was transferred from him to her. So that's the type of stuff that they're talking about in this section. And then they have two notes at the bottom. Note number 10, the government will provide defendants with any additional certifications as they are received, and the 7th Circuit has allowed notice to be provided only days before trial. So they let you know they're about to pull some sneaky stuff. See United States versus Bledsoe, 7th Circuit, 2003. 7th Circuit upheld the admission of business records pursuant to 902.11 certifications, even though the government gave defendant notice of its intent to use the certification only 4 days prior to trial. So cutting off the time to explore, investigate, and to create a defense for what they're doing. So number 11, the government may decide to call witnesses from one or more of the identified businesses if the witness has additional information beyond certification of the business records that would be helpful to the jury's understanding of the records. Okay. Conclusion, thank God. For the foregoing reasons, the United States respectfully requests that the court grant the government's motion in limine. Okay, so they filed 16 motions here. So we're going to see how many Judge Lebenweather will allow to take place. Okay, and then they have an exhibit, and the exhibit is the business entities and the business records that they are referring to, that they certified, an American Express, financial statements and account records for Daryl McDavid, Bank of America, financial records and account records for Rashona, Citibank, financial statements and account records for Winkler and McDavid, Department of Homeland Security, Customs and Border Protection, travel records for Rashona and her parents, preferred travel records for Milton Brown, and then SunTrust Bank, financial statements and account records for RSK Enterprises. And so I guess with the Department of Homeland Security part, with the travel records for Rashona and her parents, I guess they are going to try and prove that he sent them out of the country during the 2008 trial, which kind of contradicts that news report that I keep telling you guys about, where the person says that they didn't call Rashona because it was a decision by the prosecution in 2008 not to call her. So maybe they are going to say now that, yeah, he did send them out of the country. So we will have to wait and see. So guys, we got through it. It only took over 2 hours to do it. But I do prefer just doing the one video and then going back and notating in the description the places where you can find each one of these motions. And that's the way I'll do it for this. I'll put the 16 timestamps for each one of the motions and tell you what those motions are all about. So that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.